Hi, this is Daryl Tuttle, and the topic of this presentation is Last Will and Testament. What is that, and what are essential elements? A last will and testament is simply a legal document that is admitted to probate, so it becomes a public record in which your instructions after you pass, instructions as to where your assets go. That's it. It's that simple. And there are a few things that you must keep in mind when thinking about a last will and testament. And the first is you must name your family members. So you need to know, who you're married to and who your kids are. And if you don't, then it raises a question to whether or not you have capacity to even draft the last will and testament. The next thing is if you intend to disinherit a child or disinherit a spouse, most statutes, probably all, but best practices is to comply with the law, which requires you to specifically name the wife of the child that you intend to disinherit, and then to state that you intend to omit that heir from your will. Otherwise, a probate court, will presume that you made a mistake, that you just forgot to mention your spouse, and they will include an inheritance for him or her. And of course, a will is about giving your property away, allowing somebody to inherit your assets after you die. And the world is your oyster, so you can do it any way you want to. The online tool available through Living Care Learning asks you whether you want to first make specific distributions. And most folks don't use specific distributions. They just leave everything to their wife or to their kids equally, but you can certainly do it, to include charities. So if you passed away with $100,000, you can start your will by saying, I want to first give $10,000 to Fred Flintstone, my neighbor. And anything left over, we call that the residue. But specific distributions, how much and to whom does the gift go? And then we get to the residue. And the residue is, after specific distributions, what's left over. And typically, a will and a residue might say, if someone's married, the residue would say, I give the residue or the entirety of my estate to my spouse. And if my spouse has predeceased me, then to my child or children, equally. Now, that raises an interesting question, and that is, what happens when a spouse or a child or a person who's inheriting your property, what if they passed away before you? They predeceased you. And then you will be required to determine, to designate whether you want the distribution to that predeceased heir to go per capita, per stirpes, or to someone else completely. And let me explain that. To illustrate, let's start with the hypothetical of John and Jane Sample. Here's their family tree. So let's suppose John Sample died. Let's go back. So John and Jane are married, have been married for a long time. They have 3 children, Joe, Tiffany, and Paul. Joe has 2 children, Fred and Wilma, and Tiffany married a man named Smith, so her name is Tiffany Sample Smith. She has 1 child named Brittany, and Paul, another child of John and Jane, has no children. So John and Jane have three kids, and they have 3 grandchildren. And unfortunately, John Sample died on December 1st, 2012. His will provided that upon his death, his estate shall distribute to his wife, Jane. Very, very typical. Unfortunately, Jane passed away shortly thereafter, January 1st, 2014. And the question is, well, how should she distribute her estate, the second spouse to die? And almost, most cases, when the second spouse dies, the mother or the surviving spouse wants the estate to pass equally 2 children. Now, we talked about specific distributions, but in our example, she intends her 3 children, Joe, Tiffany, and Paul, to inherit equally. However, the question is, what if one of the children, or all, but let's say, for our example, one, let's pick on poor Joe here. What happens if Joe passed away first? So Joe, sample in our hypothetical, passed before, predeceased his mother, and he has 2 children, Fred and Wilma. Now, the first concept to learn is per capita. So in our example, Joe, I put the big X through Joe. That means he's predeceased. So when Jane passes away, what happens to Joe's inheritance? Well, per capita means by the head, and it means that Joe's inheritance shall pass to his siblings, not his children. And so each one of so Joe, Tiffany, and Paul would normally be entitled to 1/3 of the estate. When Joe passed away first, his 1/3 under a per capita distribution will go to Tiffany and Paul. So they inherit their brother's 1/3 share. So normally they would get 1/3. Now they're getting 1/3 plus half of Joe's 1/3, which means Tiffany and Paul inherit 50-50 equally. And the bad thing about per capita distribution is that the grandchildren here, Joe's children, are disinherited. They won't receive any inheritance. That's why the more popular distribution, and I'm talking like 99% of folks who, in fact more than that, it's like almost everyone chooses per stirpes, because they want these grandchildren to inherit in the shoes of their deceased parent. So let's look at per stirpes. So here we have, remember, John, Grandpa John passed away December 1st, 2012. Jane passed away January 1st, 2014. In our example, Joe passed away. Normally, the 3 kids, Joe, Tiffany, and Paul, would each receive 1/3, 1/3, 1/3. If this was per capita, Joe's 1/3 would go to his his brothers and sisters, so they'd get 50-50. Under a per capita distribution, Joe's 1/3 goes to his children 50-50 equally. That's called a per stirpes distribution. And so on the Living Care Learning form, we ask you to choose, in the event that one of your heirs passes away, do you want it per capita, per stirpes? Most people choose per stirpes because they don't want their grandchildren or the child of the predeceased parent to lose their inheritance. So that is the difference between per stirpes and per capita. Once again, most people choose per stirpes, so think about that. And then, of course, the last choice is if one of these children predecease, well, we don't want to do per stirpes or per capita. We just want to name a different person. I've never actually seen that happen, but it's an option available to you, and you get to decide how you want to do that. That concludes the overview of residue, or how to distribute residue of the estate, the lion's share of your assets, in the event that one of your heir predeceases you. We talked about per capita, we talked about per stirpes. Next, I'd like to go through a walkthrough, and in a separate video that you should see on this very page, I will talk about essential elements of a last will and testament, and then just give you some tips and some suggestions on how to fill out the form so you can create your own last will and testament. Or you can start your own legal document now by, if you're not on livingcarelearning.com already, go to livingcarelearning.com and you can start your own last will and testament online. And you simply start by clicking on the Create Your button at the top menu, and then just choose the legal document you want to start. Financial power, healthcare power of attorney, last will and testament, revocable living trust. And what can I say? We designed it to be easy with a lot of tips and information to help you answer all your questions.